So, no, I wouldn't say I have a passion for HR.
Welcome back to Human Resources for the People. It's a human capital revolution. Today we're going to be talking about an interesting letter from the Occupational Safety and Health Administration. They do these standard interpretations, which what a standard interpretation is a scenario where an employer or someone of interest writes to OSHA and asks them a question, and then the intent is for this question to be a clarifier for future policy. OSHA writes so many policies, it's quite confusing. There's a lot to it. And as a result, people need to write these letters to get clarity and understanding out of OSHA policy. And this one today that I'm going to be talking about is really interesting. It was published recently, and it talks about a record keeping regulation contained in 29 CFR Part 1904, recording and reporting occupational injuries and illnesses. So specifically, this surrounds the question of what is a recordable incident. Recordable incident, for those of you who don't know, is a workplace incident or injury that is required to be recorded and reported by employers. OSHA mandates that certain work-related injuries, illnesses, and fatalities must be documented and reported to ensure that employers are maintaining a safe and healthy work environment for their employees. And what this really means is that, frankly, a lot of your employers are judged based on on recordables and recordable rates, and recordable incident rates, and days away from work and things of that nature. And people look at this, managers look at this, CEOs look at this, they understand the importance of a recordable incident. And so the key criteria for determining whether or not an incident is recordable is whether or not it's related to work, has to be work related, occurred in the course of employment, was caused by a workplace hazard. They have to have medical treatment, so an incident is considered recordable if it results in medical treatment besides first aid or beyond first aid. So first aid is just non-medical personnel providing things like cleaning and bandaging minor cuts, scrapes, and burns, and that's those first aid instances are not considered recordables. Also, if an employee is caused to miss days away from work, it's generally recordable. And all of this has a bit of gray area and a little bit of nuance, but you get the idea. Any incident that results in a loss of consciousness is a recordable. Any incident that has restricted work or job transfer is recordable. And finally, of course, any fatality. And these are all recorded on the OSHA 300 log, the OSHA 300A summary, and the OSHA 301 incident report forms. So that gives you a good idea why this is really important to understand the difference here. And this lawyer, writing on behalf of a company, wanted clarification whether an employee's injury would be considered work-related as a result of an act of violence. And so what happened, this was a real incident. This was something that actually happened. The employer's driver was driving a company vehicle on the clock on public roadways, going between service calls in an intersection, and there was a four-car collision as a result of another car coming from the wrong direction. After that accident, the motorist who caused the accident shot the driver, the employee, stole their truck, and drove away. And the driver didn't do anything to provoke it. And the person was in the midst of a serial crime spree. So what Mr. Vance, the lawyer on behalf of the client, is asking about is whether or not the shooting injury sustained by the driver was work-related. Did the factual circumstances of a unforeseeable third-party criminal act rebut the geographic presumption of work relatedness? What that means is they're saying, well, it was just a random act of violence. He wasn't involved in anything specifically related to work, and he wasn't doing anything other than driving a company car, and yet and whether or not that is work related or not. And I find this to be really interesting with the context of OSHA because, on its face, this person, while driving a company vehicle on the clock is not, the company did not cause any of this violence, right? The company did not, there was nothing wrongdoing on the part of the company and nothing on the wrongdoing on the part of the employee. So, what is this a recordable injury or not? Because as we've talked about before, work relatedness is really key. So OSHA's response is actually pretty interesting. I mean, OSHA said that an injury or illness must be considered work-related if an event or exposure in the work environment either caused or contributed to the resulting condition or significantly aggravated a pre-existing injury or illness. And so what that means is that you can have completely unrelated, uncontrollable events, and OSHA still dings you on it. Its work relatedness is presumed for injuries and illnesses resulting from events or exposures occurring in the work environment. And so ultimately, this occurred in the work environment. He was traveling from one place to another, and ultimately, even though it was a random act of violence that the company had no control over, ultimately it was a recordable injury. When OSHA is establishing the record-keeping regulation governing work relationship, work only has to be a causal factor for it. So just because he was driving, that's a causal factor. In addition, there's a geographic presumption which applies for injuries and illnesses caused by events or exposures that occur in the work environment. And so they still have to be considered work related because they're geographically involved within the work environment. OSHA then refers back to a 2001 ruling where OSHA decided not to exclude the recording of injuries and illnesses involving acts of violence against employees in the work environment, regardless of the cause. Ultimately, OSHA in that ruling decided that causal connection is established by the fact that the assault or other event wouldn't have happened had the employee not, as a condition of their employment, been in the position where they were victimized. And so as a result, it's an OSHA recordable. This employee was driving a place that he wouldn't typically be driving, and as a result, the company is held accountable to a degree. What do you think about this ruling from OSHA? I think that it muddies the water with respect to recordables and takes away from the business, the purpose surrounding judging recordables and reviewing the rates and reviewing the metrics and statistics. Things that happen that are outside the employee's control or employee and employer's control, shouldn't really be held against them, in my opinion. Leave a comment down below. Let me know what you think. Like, share, and subscribe, and I'll see you on the next video. Bye, guys.